L.B. Sullivan sued the New York Times for $500,000, an astronomical amount for that time. But that was just a fraction of the total the Times was facing in libel suits from Southern officials, because the governor of Alabama announced he was going to sue for $500,000. Others jumped in, and suddenly the New York Times was looking at $7 million in lawsuits. And they weren't alone. By the mid-1960s, officials across the South had sued news organizations for libel for a total of nearly $300 million.
And this is 1964 dollars. $300 million is enough to put the newspapers out of business.
By awarding huge damage awards, institutions like the New York Times and the Washington Post and the Philadelphia Inquirer, Chicago Tribune would simply stop covering these stories. The goal was to shut up those who were saying negative things about the state of Alabama or Mississippi or Georgia. And so basically what was at stake was the freedom of the press.
In addition to the Times, L.B. Sullivan sued 4 activists from Alabama: Ralph Abernathy, Solomon Seeley, Fred Shuttlesworth, and Joseph Lowry, the only Alabama residents who signed the ad.
I ended up being one of the lawyers to represent them. If it had been just with the New York Times, the case would have been transferred to the federal court. But if you had some local Alabama residents in the case, then it would have to be tried in the local Circuit Court of Montgomery County.
And in court in Alabama, the New York Times' chance of winning were not so great.
It was a setup from the very beginning that they were going to lose.
Southern jurors were very likely to be unsympathetic. There were virtually no African-American jurors, if any, in these cases. And the judges were very hostile to the federal government or the northern attitudes about segregation.
The Times not only couldn't rely on the Alabama court system, it had trouble finding a lawyer who would represent them in Alabama.
Libel laws tended to favor those making the libel claim. To defend itself, the Times would have to prove that every word of the ad was factually correct. And that was a problem.
There were some inaccuracies in the ads.
The ad stated some students had been expelled from an Alabama State University for leading a demonstration, when it was really for demanding service at a Montgomery lunch counter.
The governor had the State Board of Education expel those students.
It stated that police had surrounded a demonstration in a ring.
They didn't ring the demonstration. There were a couple of police standing there.
That protesting students had been singing My Country 'Tis of Thee.
And in fact, they were singing the Star Spangled Banner.
And that police had arrested Martin Luther King on petty charges 7 times.
They'd only arrested him 4 times.
Even though the rest of the ad was correct, those mistakes made the ad libelous in Alabama. L.B. Sullivan won his lawsuit against the New York Times. The jury said the First Amendment does not protect libel, and the false statements in the ad, no matter how small, were defamation.
Since all these things were not true, then they printed false material that hurt his reputation. $500,000 they gave Sullivan. A verdict of $500,000, even though his name was not even mentioned in the article.
The verdict was particularly hard on the 4 civil rights leaders from Alabama. While the New York Times had money to appeal, the Alabamans had their assets seized.
They sold their cars because they couldn't stop the judgment. And in Abernathy's case, he owned an interest in some property. They sold his interest.
They lost in the Alabama Supreme Court, leaving them only one option, the Supreme Court.